things that we have in the profession.
I went to my room. I just had my table in my room, and I was working from there.
But I wasn't really getting the sequence of the very important webinar. I feel I should ask David whether I can just make my very modest presentation.
Yes, please. Yes, please. Go ahead, sir. Go ahead, sir.
Okay. So I would say that I would be as informal as possible, or I would try as much as possible to make the conversation relaxed. So let me just briefly tell my story. I was called to buy in July 2021. And in what appeared to be one of the most dangerous career decisions, I started my law firm immediately. And when I started the law firm, a lot of questions came up. Whether you can practice law without experience or without any experience. Some raised serious concerns about the fact that you need to undergo pupillage so as to learn how to go about the profession. But I took the dangerous, I call it dangerous because it is dangerous. I took the dangerous decision because I was very convinced that with my training at the Nigerian Law School and the training I've garnered elsewhere, the experiences I've garnered elsewhere, even before my call to the Nigerian bar, I was very confident that I would do very well when I get into practice. And that was it. And that was how it all started. So, yes, I have passion for litigation. The question is, how could you have charted your way around it when my colleagues, even up to now, some of them will still be left with no option than to still follow their principals to court, still check how things are done and all of that. I believe everyone has their part to take in life. So tall and short, it all started and the practice started one way or the other. And I remember that in August 2021, I filed a fundamental rights suit because I'm a human rights lawyer. I filed a fundamental rights suit with the knowledge of what I was taught at the law school. Now, when I filed that suit in August, the suit was assigned, the suit was served, and when I saw the response from the lawyer on the other side, I was just convinced that I was on the right path. Because the quality of that process, the errors I was seeing here and there, I knew that no, if this person who says, oh, we are experienced, could have done this and could have put up this very watery defense, I was very confident that no, I will do well in the profession. I was very confident. So, and it all started. When they filed their response to that fundamental rights suit, I replied to the suit. And unfortunately, we kept going to court. The judge would say she's not ready for hearing of the matter. She has too many cases and all of that. At the end of the day, I won the matter. And the court awarded about 3 million naira in damages in favor of my client, and ordered that my client be released immediately and unconditionally. But even before that judgment came, in, I think, October 2021, there was a matter I was involved in where that was filed by a senior advocate, where the senior advocate instituted the action. And after I instituted the action, when we were briefed, we looked at it, we filed a notice of plenary objection alongside our defense. And our objection was essentially saying that the suit was an abuse of court process. And when I was called in, the suit was before Honorable Justice Bogoro in Lagos. When I was called in, because in Bogoro's court, because it's a very small court in Federal High Court Lagos, they would ask everyone to go out. Maybe if your case is number 8 to number 15, they will ask you to go out. They will ask number 1 to 7 to stay. So I stepped out, but when I stepped out, I discovered that I was asked to come in almost immediately. They called my case and asked the counsel in representing defender to come in. I indeed went in, and when I got in, I saw that the lawyer on the other side was a learned senior advocate who came on by himself with juniors who were most likely at the time my senior. The learned still argued very passionately his opposition to our plenary objection. And because I was new, I couldn't even adumbrate. I just moved my plenary objection and sat down. The learned said if my lord would permit him to say 1 or 2 things, but he said so many things. At the end of the day, when judgment came, we won the matter. The matter was dismissed for being an abuse of court process, and the court lacked, and on the basis that the court lacked jurisdiction. You see, that significant judgment gave me all the boosts in my career. It gave me the confidence that, look, litigation is not necessarily a magic. Litigation involves taking time to learn the basic principle that works with it. And that is what I've learned in the past close to 3 years that I've been in active legal practice. That there is no hard and fast rule, if you ask me. So excelling in litigation, your grade do not matter. Your grades in school do not matter in litigation practice. I wouldn't know in other area of practice because I'm not so prominent in those areas. Whether you graduate with a 2-1 or 2-2, it doesn't matter in litigation practice. Now, again, when I started, a lot of people would tell you they don't like litigation. We ask them why are they not in love with litigation? They give you reasons. When I was at the law school, they will tell you that, when you ask your friend, no, everybody wanted to be a corporate and commercial lawyer. Almost everyone wants to be corporate and commercial. Maybe sometimes they are poo-pooed by the things they see on LinkedIn and social media, where they hear a law firm has advised on a multi-million-dollar deal, which comes usually once in a blue moon. So everyone just wanted to be a corporate and commercial lawyer, but I knew I wanted litigation. And I was working actively towards becoming the kind of advocate I've envisioned for myself. Look at it. I would say again that there is no hard and fast rule to becoming an excellent trial lawyer. But the major rule that is very constant is diligence. Because litigation is very stressful, you cannot afford to be a lazy litigation lawyer. A litigation lawyer must take the decision to say, look, I want to practice litigation. Now, if you want to practice litigation, you must, because it must be a decision that you want to practice litigation. You must take the decision because challenges would come. Frustration will come along the way. But that very decision is what will keep you going. I think that, one, we must understand that everywhere in the world, there are litigation lawyers. Everywhere in the world, we have litigation lawyer, because disputes will always arise in human endeavors, and litigation lawyers will be called upon to, represent parties in these disputes. But I am afraid that majority of young lawyers are running away from litigation because of the traditional sense of litigation. We have gone beyond that stage. As a litigation lawyer, you must be able to wear the path you have chosen like a sleeve. You must be proud of it. Now, I think litigation is an option. Why do I say so? I say so because we need, at this moment of our legal history, we need a crop of young lawyers that are passionate about litigation and are ready to do things differently. The litigation practice as it is now is not sustainable if we don't have a bit of fresh air. When you read some briefs by lawyers, by litigation lawyers, you wouldn't feel impressed. But I can tell you that when you read some briefs, some court processes from some litigation lawyers, you would want to practice litigation all your life. So the question is, what kind of litigation lawyer do you want to become? Do you want to be a mediocre litigation lawyer that uses all tactics to get adjournments, that wants to frustrate proceedings? Or you want to be an amicus curiae, a friend of the court? Do you want to be that kind of lawyer that helps the court to arrive at justice whilst protecting your interest? I think it's important that if anyone chooses litigation, they must make the decision to distinguish themselves. Distinguishing yourself comes with a lot of diligence, I must say. A litigation lawyer, especially as a young litigation lawyer, you cannot afford to be shabby, whether in your appearance, in your approach to the court, or in your processes. You must take steps to ensure that you distinguish yourself amongst the lot. Because if you fail to distinguish yourself, you are not making any contribution to litigation practice. So if you bring your dedication, your industry, your brilliance to the practice, I think you will make a difference. You will shine. There is no shortcut about it. But you cannot be outstanding in litigation if you are not on top of your game. And you can only be on top of your game if you continue to read. You see, litigation is about diligence. I have friends that are excellent trial lawyers. They're excellent litigation lawyers. Yes, you get better over time, but you must be very conscious of your moves to get to become a better litigation lawyer. I was talking to one of the finest litigation lawyer I know in this country, young litigation lawyer I know in this country, recently in Abuja. I said, Augusta, I have a case at the Federal High Court somewhere in the Southwest where a lawyer, where a law firm signed the court process, where in the court process there was no single relief, whether in the writ of summons or in the statement of claim, not a single relief. The lawyer started laughing. He said, Festus, do people still make this kind of mistakes? I said, Augusta, yes, they make this kind of mistake because they are not even aware that they are making mistakes. They are not aware of latest judgments of the courts. They are not aware of, approaches to doing things, new way of doing things. They are still restricting themselves to the old ways. If you are not on top of your game, you don't have a business if you cannot be on top of your game at every time, you don't have a business in litigation. You must know it. You must know what you are doing in litigation. If you don't, you will make a mess of yourself. It requires hard work. It requires a lot of hard work. So if, for example, I get a court process, the first thing I look, before I even look at the merits of that, I want to see, what is this lawyer? What kind of lawyer is this? And when I begin to see, oh, the lawyer, we have 5 lawyers on the list. One of the lawyers is not, the lawyer that signed the court process is not ticked, no MBA seal. Okay, that's good. You begin to look at it, you begin to point out errors. And that is the way litigation is, unfortunately, in Nigeria. You can't be an excellent litigation lawyer if you don't have excellent knowledge of technicalities. And you don't have knowledge of technicalities if you are lazy. There is no room for laziness in litigation. You have to be up and doing. You have to be on top of your game. Now, if you work in a law firm, the law firm must be able to rely on you for value, for contribution. How do you do that if you don't even know what is going on? If you don't read cases, if you don't read articles, if you don't know the latest trend. I mean, you see, when I see lawyers make blunders, I just laugh. Unpardonable blunders. You are deposing to an affidavit. You didn't mention that you have the consent of so person to depose to the affidavit. You didn't mention whether the affidavit is within your personal knowledge or information of belief. You said you got information from another person. As a litigation lawyer that drafted the affidavit, you did not state the conditions for a third party or a second party evidence in your affidavit. You filed a computer generated evidence, you have to tender it. There is no certificate of compliance orally or filed in court. When the lawyers on the other side see that you are doing that, they know this person doesn't know what he's doing. So you wouldn't even be accorded with respect that you deserve as a lawyer. So I think that one important thing or one important skill a trial lawyer, a litigation lawyer must have is to be very diligent. Not just diligent in doing the work, but diligent in amassing knowledge without necessarily trying to sound immodest. The level of knowledge I consume when it comes to litigation is what, in my respective view, keeps me going. Because if I see anything, either arbitration, which I will still come to, or alternative dispute resolution, I will read because it will be useful for me. Oh, you think, oh, your law firm only does tenancy matters. I can tell you that you should not restrict yourself to it. You must read law reports as a litigation, read law reports. And when you are angry at an authority, you must have the confidence to marshal your argument, whether in court or in your processes. One thing that I do very well, which experience has equally taught me, is that I try as much as I can to be very detailed in writing my processes. Because as a young lawyer, you might not be given the opportunity to showcase your advocacy skills for now because you are still young. You say, Mr. Ogun, is it in your processes? You say yes. So what do you want to say as the court pleases? The court will not ask you to adumbrate. Even when they want to ask you to adumbrate, they will say 3 minutes, 4 minutes. So because you know that, what you should do is to always ensure that your court processes are always detailed. I think it remains to add that you must be a person of integrity. You see, it hurts me on a daily basis when I see senior lawyers. I say it with all due respect. When I see senior lawyers do some things in court, I was at a federal high court somewhere in Southwest recently. I stood up and I told the court that, my lord, this thing happening is so painful, because I will be very truthful to the court. That, my lord, this thing is painful. Sharp practices. You must, to distinguish yourself, you must do away with sharp practices. You must eschew it. You must run away from it. Be a person of integrity. but do your cases very well. Avoid sharp practices. A night to the court process, to the day the matter is coming up, you are writing a letter for adjournment. Sharp practices. You say you are not ready, giving flimsy excuses. I can tell you all that since I've started practice, I've never gone to court to tell the court, hey, we are not ready. I have not filed this. I can't go because I feel my integrity is on the line. Why won't I file what I ought to file? Why should I go and tell the court that we have not filed? So I feel that to become an excellent trial lawyer, it is very taxing. It is very taxing. It takes a lot of industry, takes a lot of effort, it takes a lot of hard work to be an excellent trial lawyer. But in the end, if you genuinely love it, you feel that satisfaction when you see that the problem of your client is solved. Over here at FLEGA, I tell you that our mission is to solve clients' most complex challenges. So I'm not really motivated by simple challenges. I want very complex challenges. Now, if I can solve complex challenges for clients through litigation, then I feel satisfied. So if what you desire to have is a name that identifies you with excellence, I think that you need to be very hardworking and you must be very ethical. I've spoken about that. You must eschew and avoid sharp practices, and you must be on top of your game. And you can only be on top of your game if you read court judgment. There was a time I read court judgments when I'm bored. When I say hard all the time, so I mean I just consume judgments because they will be useful. It's also good that you have a practice note. So you have a practice note where you jot down principles of law. I mean, basic principles. Very basic principles. I mean, as a litigation lawyer, there are things that you should know. There are basic principles that you should know. But you will be very shocked that some do not know it and they are doing it. Now, you will be on top of your game and you will make commercial sense of your practice when you're on top of your game, because you begin to defeat those who are not on top of their game. It's as simple as that. So some people also run away from litigation because they feel, oh, it's not lucrative. That is false. That narrative should be rejected. That narrative should be treated with, or like a pinch of salt. It is something that should be disregarded as a mere petulant and treated with ignominy. Why do I say so? Why do I say so? I say so because litigation is very lucrative. There are billionaire litigation lawyers whose only job is litigation. But so the kind of income you make from litigation depends on what you want. If you want to be a litigation lawyer that resolves that handles oil and gas disputes, maritime disputes, that is good for you. I mean, that's what you want. But you cannot compare the income of that person with a litigation lawyer that specializes in defending petty offenses, laundering, stealing, magistrate court offenses, or tenancy. Yes, you are also a litigation lawyer. You are very excellent in that area, in litigation. But the areas of practice that you have chosen will determine the kind of motivation that you will get at the end of the day. And motivation in litigation doesn't come immediately. You don't start today and you want to be charging 50 million, 100 million naira, like senior advocates. You want to charge 500 million. You want to earn 400 million from a brief, which senior lawyers, even non-senior advocates, are earning from litigation. But you need to understand that it's a matter of time. You must understand that you cannot start litigation now and begin to rake the millions now, because you will get better over time. You will have to own your skills over time. But I am telling you that if you are able to endure the pain of today, I'm very confident joy will come in the morning. Joy will come tomorrow. Because litigation, disputes will always arise in every aspect of life, whether everywhere. I don't even want to, every sector, there are litigation. Even among family members, there are issues, there are disputes that result to litigation. So a litigation lawyer has the prospect of earning well almost on a daily basis, because there will be disputes. And you can also advise on dispute avoidance. You can also advise people on how to avoid disputes, which is also part of your job as a litigation lawyer. Even after judgment, you still have that role, because you have knowledge of litigation. You can still advise as a litigation lawyer. I think one other thing I would want to say is that to be outstanding as a litigation lawyer, you must have knowledge of substantive law. You must have knowledge of substantive law in the area of litigation that you profess to practice. So if you say you are a litigation lawyer, some will say they are a generalist, but I think we are leaving that phase, right? But if you want to, be a litigation lawyer known for litigating some areas of law, you must first of all understand the law in that area before understanding how to litigate. Before, aside your knowledge of litigation, you must understand the substantive law in that area. So if you are talking about maritime, I'm not a maritime lawyer, for example. You must understand maritime law. You must have basic knowledge of maritime law, so that when the dispute arises, you are able to advise them and you are able to represent properly. But these days, some litigation lawyers are only focused on technicalities, knowing the rules of court, knowing how to maneuver their way in court. No, it's not enough these days. Clients are looking for lawyers that have knowledge of their industry, have knowledge of the laws in those industry, and now have the skills of representing them when there is a dispute. So you cannot afford to just say, I'm a litigation lawyer. How about your knowledge of those areas you are litigating? Do you have the substantive law knowledge of the law of those areas you intend to litigate? So I think one other thing that can distinguish you is, being outstanding, understanding the substantive law of the areas that you intend to litigate for your clients. That will even attract clients who knows that, look, this person that wants to litigate this matter for us, or that wants to represent us in this matter, has a knowledge of our industry. This person has a fine knowledge of the banking and finance industry. So when there is a banking and finance dispute, we know we can go to him, because he not only has knowledge of the law, he also has knowledge of our industry, and he also have the skills, the requisite litigation skills to represent in those matters. Again, the era has gone when you should just be a trial lawyer. Now, as a litigation lawyer, as a dispute lawyer, you must understand that we are in the era of alternative dispute resolution. So you cannot restrict yourself to going to court alone. You also have to look at arbitration. There are some lawyers that the only thing they do is arbitration, which is good. It's also part of dispute resolution, and is a specialized area of litigation or of dispute resolution that young lawyers can also look at to become thought leader in those areas and to be known to that area, so that you begin to work in that space. We also have mediation, another alternative dispute resolution mechanism. So it is not just enough to just restrict yourself to going to court where you get adjournment on a daily basis. But, largely due to the inefficiency of the system, and sometimes due to the inefficiency and unseriousness of, some lawyers. So I want to charge everyone who have chosen this part of litigation to hold on to it. I don't see any reason why any lawyer should give up on litigation. If you distinguish yourself, you are going to shine. If you distinguish yourself, you will go far. If you distinguish yourself, you will end well. For me, I've never seen a lawyer, a litigation lawyer that knows what he's doing, that positions himself properly, that has knowledge of the industry, and has done the appropriate thing. I mean, doing your personal, ensuring that your personal branding are in place, pushing your expertise to the world to see, and being, an outstanding lawyer. You know what you are doing. You are very diligent. You know your work. I know a lot of them that live fulfilled life, and if the concern is about material wealth, I know a very good number of litigation lawyers that are wealthy, and I make bold to say that if the fear of if commercial reason is why lots of young players are leaving, if you are to compare the number of successful lawyers, I think litigation lawyers will take the number. Why? Because the commercial practice we talk about is restricted to the commercial cities, and lawyers in Nigeria are not only in commercial cities, so the outstanding lawyers everywhere are mostly litigation lawyers. And the knowledge of litigation is so crucial to the survival of our profession. So I just hope I've been able to touch on one or two things that I think is helping me in this journey to become an excellent trial lawyer, like I would always say. I think I've just said one or two things that everyone here will take home, and I'm hopeful will help them in their career trajectory. Thank you very much, David, for the invitation.
Thank you very much. Thank you very much, sir. We are super grateful for the value you have already turned out. Please, let's just react, and then in the comment section with emojis, let's show our speaker that we are super grateful. So for those joining us, I know you might be seeing Afolabi Alawode on the name. That is not his name. His name is Festus Ogun. He's actually using the system and account of a colleague. All right. His name is Festus Ogun, managing partner FO Legal, not the name you are seeing there. All right. So we appreciate you, sir. Now it's time for questions. We have about a 15-minute window for questions. So the floor is open. It's question time. If you have your question, you can either raise your hand and then you go ahead and unmute, or you type it and I read it out for you. So it's question time. Okay, Ayo says, thank you so much, sir. I've been enlightened the more. Thank you very much, Ayo. I myself have been enlightened. Okay, so question time. Okay, so while we are waiting for questions to come up, let me go ahead and ask my own. Mr. Festus, sir, I don't think I'm the right person to be moderating this session. Why do I say so? The reason is, okay, we have a question from Manuel. Let me just go with mine first. The reason is, I had my first, I'm not known for, my colleagues don't know me as a litigation lawyer. They know me as a lawyer who is largely into tech. I'm actually an in-house counsel company. So, but on Sunday night, I got a call from a colleague that, CEO, I have a matter. I need you to please hold my brief. I say, since they called me to, but I'm not going to court. I don't work in the firm. What do you mean by that? So do you know that I had my first appearance in court on Monday morning? The matter was coming up for the first time. If you know, I've done most and more, but this time around the feeling was different. I had shaky feet, I won't lie to you. Only few of my friends, the Emmanuel and Erin. That was magistrate court, Carol, in Abuja. I just came into Abuja. I just called me, good 18. I had to rush down. I was able to have my own little dose of litigation. Although I stayed, the matter was number 10 on the cost list. I know how magistrate court matters can be. But it was a good one, and fine, it's a good thing I'm hearing this today, because he told me that I will continue the brief at the next adjourned date. I told him I'll think about it. But from this call now, I think I will go for it. Thank you very much, sir. I appreciate it.
Thank you.
Thank you very much, sir. All right, so Mr. Manuel, let's have your question. Just tell us your name, Tell us your name and then your question.
Good evening. I hope everyone can hear me loud and clear.
Yeah.
Okay. My name is Emmanuel Ademuete. I first of all would like to extend my appreciation to Mr. Festus for a very well delivered session where he hammered on excellence and commitment in delivery of your goals. One question that I still have, however, is how you can publicize that commitment in such a way that you attract and keep high level clients without soliciting, right? Without going out of your way and breaching what the RPC says. How do we get those clients that stay? That's my question.
Well, thank you. I think that's more of the business side. You know, all the while I've been talking about the legal side of it. I mean, the knowledge part, how to handle cases and all of that. So when it comes to the business part, well, I wouldn't say I'm a big lawyer yet. I'm not a big lawyer, you know, but I would say that one thing is this. You are most likely, as a young lawyer, you are most likely not going to get the big briefs yet. Just take that. You are most likely not going to get it. But you must be conscious of excellently handling all briefs that come your way, to the point that you can be entrusted with bigger ones. I made my first millions from litigation in my first year of practice. First millions from litigation in my first year of practice. Now, I mentioned that you must, first of all, position yourself as someone that has knowledge in specific areas of law that you want to see clients. So, take for instance, you want to, in coming years, some of us have a vision, there will be a lot of privacy disputes because of the advent of data privacy and protection. Now, you want to be seen as a lawyer, a lawyer that handles dispute resolution in data privacy and protection, or arising from data privacy and protection. First, you must show that you have knowledge of data privacy and protection. You must show that you have knowledge. You must demonstrate. It's not a breach of RPC to write articles, to host events, to volunteer in events that relates to that area of law. I don't think it's against the RPC to have a podcast or write a newsletter. I don't think it's a breach of the RPC. And I also know that it's not a breach of RPC to have a YouTube account where you create, content relating to the area of law that you envision you get clients. So, issue of attorney marketing is something different entirely. But when a client comes your way, some senior lawyers will say it is easy to get a client, but it's not easy to retain. If you don't deliver results, clients will not bear with you. No client bears with you. They will only stay when you deliver. And when you deliver, you get more recommendations. In my early year of practice, very early days, I'm talking about the first few months, I got a brief November 2021. It was a very simple matter. They came to me to say, look, Mr. Ogun, last task force in Lagos have impounded my vehicle. I didn't do it, this and that, blah, 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 and I've been charged to court. I went, they did his arraignment, and that was even my first trial. He did. The policeman came, I cross-examined him, I prepared. In the end, we won the matter on the merits, not on technicality. Do you believe that that client that I did that simple matter for, at a very discounted fee, very discounted at the time, That man has brought a lot of clients to my office. And that is how litigation works. Sometimes litigation is not just about you showing that you can do it. It must be seen to have been done. And for example, when I started doing election cases in 2022, when I started doing pre-election matters, started, commenting on recent developments in election cases. That mere fact that I was always on top of every legal development at that period, at that election period, every legal development in the election sector, I got a brief from far away Katsina State. Someone just read the article, and I went there for election petition in 2023, last year. Now, we were able to successfully represent that client. If that client wins the election in 2027, if he recontests, do you think he would go for another lawyer? But if we had lost and he had left the National Assembly, what would be our story today? He won't come. He is most likely not going to come back to us. He would rather go to the lawyer that defeated him at the tribunal. So these are the things that I emphasized about excellence. So that excellence will take you far. You see that big clients you intend to get, you will eventually get them when you are on top of your game. But if you are not excellent at what you do, you will not be taken seriously. And I mean, I was telling one of my friends, I will round up now. I was telling one of my friends that, look, do you expect the way you in your office, the way you are doing 5 million naira disputes, you are doing 5 million naira disputes. That is the same way some people are doing 5 billion naira disputes. So, but for parties to a 5 billion naira dispute to entrust that, look, this man can handle this dispute for me, you must have shown workings. You must have shown excellence. And that is why I always emphasize on being outstanding at what you do. But it is very rare or most unlikely for you in your first few years of practice to start handling sophisticated disputes as a litigation lawyer. But what have you done with the little ones that have been entrusted to you? That is the question begging for answer. Thank you.
Wow. Thank you so much. Thank you so much. Excellence is key. I believe that has been addressed by FO Legal accurately. The next hand, before I read the chat, is from Erin. Erin, please go ahead and mute and ask your question. We still have about 7 more minutes for questions. If you have any, please raise your hand or type it in the chat box. Erin, you can ask your question, please.
All right. Thank you very much, David. Thank you very much, Mr. Festus, for the well-delivered piece of advice to everyone. So my question is simple. Being a new wig, being a trainee in a very busy firm, which leaves me with so much to do, such as drafting, appearing, filing, how do I get to carve out time for myself, for personal development, to align myself with my future goals in terms of dispute resolution, such as arbitration, which I want to venture into?
Nothing other than discipline. It's all about discipline. It's very, very difficult to put oneself out there, even as a commercial lawyer. It's very difficult. It's taxing. Because we all know litigation takes time. But you also know that you cannot continue to be, you cannot afford not to be out there. People have to see you. So, and that is the only way you can grow as a lawyer. Apart from your knowledge, people have to see. Prospective clients have to see you. You are brilliant, but nobody knows that you are brilliant. You are not there. You are not out there. But you have to create time for it. Unfortunately, that's the truth. Do you know that in the beginning of this year, I wanted to start a podcast? I have someone that had even set it up for me, but I didn't have all the time. So I had to go back to what I know how to do, which is to write articles, to do research. So the point I'm making is that I think it takes a lot of discipline. You just have to discipline yourself. You have to be realistic with your discipline, with your goals and expectations. When you map out the plan, okay, this year I want to write 6 articles. Oh, this year I want to attend so events. I want to do so. I want to do so and so professional exam in furtherance of my future goals. You have to be disciplined. That's the truth. You have to create the time. Because if everyone is saying, I don't have all the time, nothing will be done and nobody will be outstanding. But your ability to do extraordinary things, even with the tight schedule that you and your colleagues have, is what makes you an excellent person. And that's the truth. You see lawyers, they say, oh, litigation is busy. But some lawyers never left litigation. They never left for a day. They have a PhD. They never left. They didn't travel out of Nigeria. And they possess a PhD. Some have master's degree. Well, you continue to say, oh, litigation it requires time, I have to focus. But time's wait for nobody. You still have to get the work done. Yet, you still have to develop yourself. The question is, as a litigation lawyer, how do you have time to read cases? I mean, I'm not saying you want to read case to reply to a process or to file a lawsuit. No, you just want to read the case to develop yourself. Or you want to, be on top of your game. I think it requires a lot of discipline and planning. May God help you.
Amen. Thank you,
Thank you
sir.
very much. Thank you very much, Efoliga. So the final question here we have from Wayren Theophilos, and I think I also had that question in mind was, what's the metric? What's the metric for charging our clients? What metric do you use to charge your clients? That's it. And okay, someone just asked another question.
So let me quickly. I'm sorry. Let me quickly
address it. Okay.
When it comes to
very well.
Address that. When it comes to charging clients, one, it involves a lot of things. One, yourself. You can't start charging recklessly. You can't start charging outrageously because they know you are a young lawyer. They know, but you must also charge reasonably. You have to look at the brief. You have to look at the complexity of the brief. You have to look at the clients. You have to look at the clients to know how to charge. So you look at yourself, you know yourself. You look at the complexity of the matter. You look at the side you are, the reputation of the lawyer on the other side, and you also look at your clients. So if, for example, you are briefed by a governor, or a governorship candidate, not an aspirant, in election cases, you can't be talking, assuming you'll be doing fundamental right for 500,000 naira, 400,000 naira, 300,000 naira. Now, a senator is calling you to file fundamental rights when he was arrested in relation to a matter where ESQ say he has stolen 10 billion, they detain him for 7 days, you want to file, and you tell him 500,000 naira. You've not charged well. So it's expected that you look at the client, you look at the matter, you look at the complexity of the matter, you look at who is on the other side, then you charge. And another skill, one thing I do is to say, look, you give them discounts. So you tell them if I should do this, give clients options. Let them feel at home. Give them, as though you want to charge 1 million for a brief. You look at it. Is it contentious? For how long? You can say, okay, for me, I will tell my clients, look, this man, when I look, it's not let me say it's not a really serious matter, or I've looked at the merit, I know we are going to win easily. I can tell you, well, If you want me to come back for appearance fee every time, because personally I don't like appearance fees. If you want me to come for appearance fee every time, I can ask you to pay 750,000 for this assignment. Oh, Mr. Ogun, that's too much. Oh, okay, pay 700,000 naira. But my appearance fee is 50,000. My appearance fee is 30,000. My appearance fee is 50. Or you just pay wholesomely and pay 1.2 million. Now, you have given them options. That is the business aspect. That is to show you that you're also trying to play on their intelligence. You're also trying to get to them. So they feel okay. Instead of giving this, because I know this matter can take 2 years, instead of giving this lawyer 50,000 anytime he goes to court, why not just pay him 1.2 or 1.5? That is how to charge. So you look at your client, or sometimes you can give them structured fees. Structured fees. There was a client that was talking to me one of these days. Oh, she said that if she's to pay that money at a goal that it will be impracticable for her. I told her that's not a problem. I said, can you do 50% at first? She said, no. You can't. I said, okay. Because I'm also a businessman. I said, now, come. Let's do 25%. Oh, she was even the one that proposed she would do 25% for me to start the drafting. Immediately I filed. Once service is to be effected, she will pay another 25%. That's 50%. When the matter is ripe for trial, she will pay another 25%. That's 75%. And when the matter is ripe for adoption of written address, she will pay 25%. That's 100%. You get your money. But sometimes when you charge, they are afraid of the money. But give them options on how to pay. And you must be financially disciplined. I'm taking a lot of time because I just have to say all of these things. As a litigation lawyer, you must be financially disciplined. Because if someone gives you 2 million naira for a brief, that brief can take 2 years. So as a young lawyer, you must be financially disciplined. This is not the time for recklessness because you don't have a lot right now. Thank you.
Thank you very much. The law, the business of the law. This is amazing. Thank you very much, sir. Okay, the final question is it wise to specialize in leaving your area of interest or get a feel of various areas depending on your opportunity?
I will take the last
specialization.
I think that you should not specialize too early, but you can have areas of interest. But you should not specialize too early. I have I've laid my hands on so many areas of law right now. And when I pick an interest in an area, I go for it. I try as much as I can to get reasonable knowledge. I mean, basic knowledge in that area. If you're talking about constitutional and electoral law, I will tell you I have a knowledge of it. Does that mean if you bring labor and employment matters, I would still answer? Just last month, we won a matter, I mean, essentially on data privacy and protection. I don't have any certification in data privacy, but I've read and I continue to read on issues related to data privacy. Interestingly, I now have a lot of people coming to me to brief me on data privacy matters. Does that mean, so you should not just restrict yourself needlessly. I don't think it is needless to restrict yourself, but let people know you for some areas of law is the best. If within your first 5 years of practice, if your colleagues cannot say, oh, Morakiyo is, and oh, when you want, oh, Morakiyo, oh, you are talking about maritime. If they can't say, oh, David, oh, that one, that guy, now tech law in the do. If people cannot identify you with something in your first 5 years, if they can't identify you with something, then you must be afraid. So what you now have to do is to be very conscious about the brand you are building so that you are identified with something profitable. You have to be very conscious. You have to be extremely conscious of the kind of brand you want to build so that you are properly identified with the area of law that you feel you want to be known for. But to restrict yourself, I would say you should not restrict yourself. David, please remind me. I would send a book to you. Let every participant, if they have a platform where you can send to them an email, please send it to them. That book is called Attorney Marketing 101. It tells you how to market yourself as a lawyer without necessarily breaching the ROPC.
Wow, wow,
Yes,
wow.
I will
Thank
share
you,
the
sir.
book with you. I read it in my first year of practice. How to market yourself. You don't need to, you won't even breach ROPC to attend events. Is that breaching ROPC? To volunteer at legal events or in some industry events where you meet prospective clients. Is that a breach of ROPC? No. I will share the book with you so that everyone can read. We are trying to democratize knowledge so that everyone here will become senior advocates in the next 10 years.
We are most grateful. Thank you very much. Please let us just give it up for Festus Ogun Esquire. He has outdone himself. In fact, he overshot his time. He overshot his time. He has other things to do, but he decided to give us more time. We are super grateful for this. We are super, super, super grateful for this. So, sir, do you have any final words for us as we withdraw the curtain here? Any final words?
I have. Thank you very much for having me. One thing I will just tell you all is that your dreams are valid. I'm happy I'm living my dream. I'm not where I should be, but I know this is not where I used to be. And I'm very confident that your story will also be very, very motivating. It will be inspiring to people coming behind us. Please hold on to your dream as if your life depends on it. Please hold on to it because your dreams are valid. Anyone that tells you your dreams are not valid should not be taken seriously. Never underestimate the validity of your dreams. Again, I will insist that your dreams are valid. May God make it easy for you all. Thank you.
Thank you very much, sir. Thank you so much. Please let us go to the comment section and say thank you to our speaker. Let's say thank you to our speaker. A few announcements. The book he spoke about, I'll be reaching out to you to get it. Please join the WhatsApp platform so that then you can be able to get the book because we can't randomly start sharing the books on every platform. But we'll just share it on our community platform on WhatsApp. I've shared the link in the comments. Kindly join. And also updates as regards subsequent webinars will be shared there. Make sure you join the community of young lawyers, law students, and law professionals and enthusiasts building themselves, seeking opportunities to grow the ladder. Thank you so much, everyone. I think we're going to draw the curtain here. Watch out for the recording. Make sure you follow us on the community and follow our YouTube channel and follow us on social media to get more updates. Thank you very much and do have a blessed evening. Bye, everyone.